You open the mail. Just another day, another stack of envelopes. Bills, advertisements, the usual. But then you see it. A thick envelope. Official looking. Your name and address printed formally across the front. You open it. Your hands start shaking before you even finish reading the first line. Summons. Complaint. Superior Court. Your name, your address, and a number, a dollar amount, you recognize but can't believe you're seeing in this context. You're being sued for a debt. Your chest tightens, your breathing gets shallow, your mind races. This is real. This is happening. What do I do? What happens now? Am I going to lose everything? Can they take my house, my car, my paycheck? Is this it? That panic, that immediate overwhelming sense of dread and helplessness is exactly what they want you to feel. Because fear is the first weapon in a debt lawsuit. Fear is what makes people freeze. Fear is what makes people do nothing, and doing nothing is how they win. But what if you knew the fear was a tactic? What if you understood that being sued doesn't mean you've already lost? What if you knew exactly what to do, calmly, strategically, legally, to fight back and possibly win? This video will show you exactly what to do when you're sued for debt. What not to do, what your rights are, what their weaknesses are, and how to navigate the process without letting panic make your decisions for you. Because here's the truth, they don't want you to know. Most debt lawsuits are won not because the collector proved their case, but because the defendant never responded. Over 90% of debt collection lawsuits end in default judgment. Not because the debt was valid, not because the collector had solid evidence, but because the person being sued did nothing. Silence equals surrender in the legal system. But response, even a simple, basic response, changes everything. If you've ever been sued for a debt, or if you're scared it might happen to you, or if you know someone going through this right now, comment yes. Because this is more common than you think. Millions of people face debt lawsuits every year, and most of them don't know they have options. Most of them don't know they can fight back. Most of them give up before they even start. But you don't have to be part of that statistic. You can respond. You can defend yourself. You can change the outcome. This is educational content, not legal advice. Debt collection laws, court procedures, and statutes of limitations vary significantly by state and by individual circumstances. Always verify your specific situation with a qualified attorney or legal aid service before taking action. This video explains general principles and common strategies, not case-specific guidance. Let's start with what a debt lawsuit actually is. Because the panic you feel when you get served often comes from not understanding what's happening or what it means. Most people hear the word lawsuit and imagine criminal charges, police, jail, immediate catastrophic consequences. But that's not what this is. A debt lawsuit is a civil action. It's not criminal. You're not being charged with a crime. You're not going to be arrested for owing money. Debt is a civil matter, not a criminal one. What's happening is this. A creditor, or more often a debt collector or debt buyer, is claiming in a legal filing that you owe them money. They're asking a court to issue a judgment in their favor. If they get that judgment, it gives them legal tools to collect: wage garnishment, bank account levies, liens on property, depending on your state's laws and what exemptions apply. But they don't have those powers yet. Not until they get a judgment. And they don't get a judgment automatically just by filing a lawsuit. They have to either prove their case or win by default, because you didn't respond. That's the key. The lawsuit is not the end. It's the beginning of a process. A process where you have rights, you have defenses, you have options. A process you can participate in and potentially win. So who's suing you? Often it's not the original creditor. It's not the bank that issued your credit card or the hospital that sent the medical bill. It's a third-party debt buyer, a company that purchased your debt, usually for pennies on the dollar, in a bulk package of thousands of accounts. They paid maybe 5 cents on the dollar for your debt. Now they're suing you for the full amount plus interest and fees. They're not trying to help you. They're not even particularly concerned with whether you can pay. They're playing a numbers game. They file hundreds or thousands of lawsuits. Most people don't respond. They get default judgments on most cases. Those judgments give them power to collect. And even collecting on a fraction of those judgments makes the whole operation profitable. They're counting on you not responding. They're counting on you being too scared, too confused, too overwhelmed to do anything. They're counting on silence. And over 90% of defendants give them exactly what they want. Nothing. No response, no defense, just fear and paralysis. But you're not going to do that. Because now you know that doing nothing is the worst possible choice. And knowing what to do next changes everything. So you've been served. You have the lawsuit papers in your hand. Now what? Step 1, and this is critical. Read the lawsuit carefully. Every word. Don't just glance at the amount and spiral into panic. Actually read what you've been served with. You'll typically receive 2 key documents. The summons. This tells you that you're being sued and gives you crucial information. Which court the case is in, the case number, and most importantly, how long you have to respond. That deadline, usually 20 to 30 days from when you were served, though it varies by state, is the most important date in this entire process. Miss that deadline, and you lose by default. Mark it on every calendar you have. Set multiple alarms. That date is your first line of defense. The complaint. This is the document that lays out the plaintiff's case. It lists who's suing you, the plaintiff's name, which is often not the original creditor, but a debt buyer or collection agency. It states what they claim you owe, the principal amount, interest, fees, court costs. And it explains, at least briefly, the basis for the lawsuit, that you allegedly entered into an agreement, incurred a debt, defaulted on payments, and now owe what they're claiming. Read both documents carefully. Don't assume everything in them is correct. Don't assume they have their facts straight. Don't assume they can prove what they're claiming. Debt buyers and collectors file lawsuits with incomplete information all the time. They sue the wrong person, someone with a similar name or a relative of the debtor. They miscalculate balances by adding fees that aren't legally allowed. They sue on debts that are past the statute of limitations. They file cases without having proper documentation to prove ownership of the debt. They do this because it works often enough to be profitable. Most people don't challenge anything. Most people just accept that if they're being sued, the lawsuit must be accurate. But you're going to verify everything. You're going to check. Is the plaintiff actually who they say they are? Is it the original creditor or a third-party debt buyer? If it's a debt buyer, that creates specific requirements they have to meet to prove their case. Does the amount match your records? Does it include only charges you actually incurred, or are there fees and interest that might not be valid? Do the numbers add up, or are they inflated? Is the court and deadline information clear? Which court is the case filed in? Is it the right jurisdiction? What exactly is your deadline to respond? Some states calculate from the date of service, others from the date of filing. Get this right. Write everything down. Create a document, physical or digital, where you track every detail. Case number, court name, plaintiff name, amount claimed, date you were served, deadline to respond. This becomes your case file, your reference point, your organizational tool that keeps you from feeling overwhelmed by chaos. And most importantly, do not miss your deadline. Everything else in this process can be figured out, can be addressed, can be handled. But if you miss the deadline to respond, you lose automatically. Default judgment. Game over. They win without having to prove anything. So mark that date. Protect that date. Everything else flows from responding before that deadline passes. Now let's talk about the single most important and most overlooked defense in debt collection lawsuits. Demanding that the plaintiff prove they have the right to sue you. This is critical. This is where many cases fall apart for the collector. This is your leverage. Here's what most people don't understand. Just because someone files a lawsuit claiming you owe them money doesn't mean they can prove it. Just because they have your name and a number doesn't mean they have documentation showing you actually owe that specific amount to that specific plaintiff. Most debt lawsuits, especially those filed by debt buyers rather than original creditors, are filed with minimal documentation. They have a spreadsheet. They have your name, an account number, a balance. They bought that information in bulk. They're betting you won't make them prove anything more. But they have to prove more. They have to prove three things. 1. That you actually entered into an agreement with the original creditor. That there was a contract. That you agreed to the terms. That the debt is yours, not someone else's with a similar name. 2. That you defaulted on that agreement. That you stopped paying what you owed. That the debt is legitimate and enforceable. 3. That they, the plaintiff suing you, have the legal right to collect on that debt. If they're a debt buyer, they have to prove that the debt was legally sold to them. That there's a valid chain of assignment from the original creditor to them. That they own the debt and have standing to sue. That third one is where most debt buyers fail. Because debt gets sold and resold multiple times. Your credit card debt might have been sold from the original bank to debt buyer A, who sold it to debt buyer B, who sold it to debt buyer C, who's now suing you. Each of those sales should have documentation, a chain of title, proof that the debt was legally transferred from one entity to the next. Just like when you buy a house or a car, there needs to be paperwork showing the transfer of ownership. But debt buyers often don't have that documentation. They bought accounts in bulk, thousands at a time, and they got a spreadsheet, maybe some basic account information, but not complete documentation for every account. They're counting on not needing it. Counting on winning by default before anyone asks them to produce it. So you ask, you demand, you make them prove it. In your answer, your official written response to the lawsuit, you include language that forces them to provide proof. Something like, defendant lacks sufficient knowledge or information to form a belief as to the truth of the allegations and therefore denies each and every allegation contained in the complaint and demands strict proof thereof. You're not admitting anything. You're not agreeing that you owe what they say you owe. You're putting the burden back on them. Prove it. Show your documentation. Demonstrate that you have standing to sue. Make your case. And in many cases, they can't. So they either drop the lawsuit or they offer to settle for a fraction of what they were claiming because they know if it goes to trial, they'll lose. That's your leverage. That's your defense. Not, I don't have the money, or this is hard for me, or I'm sorry. Those might be true, but they're not legal defenses. Your defense is, prove you have the right to sue me. Prove I owe this specific amount. Prove you own this debt. Make them do their job. Make them meet their burden of proof, because often they can't. So how do you actually respond to the lawsuit? What does filing an answer mean and how do you do it? This is where most people lose by default, not because they don't have a defense, but because they never file a response. They get the lawsuit, they panic, they tell themselves they'll deal with it tomorrow, and then the deadline passes and they lose automatically. Don't let that be you. Filing an answer is not complicated. It's not expensive. You don't need a lawyer to do it, though having one helps if you can afford it or qualify for legal aid. But you can do this yourself if necessary. Your answer is your written response to the complaint. It's a formal document you file with the court that says, I'm responding. I'm not admitting to these allegations. I have defenses. I'm participating in this case. That's it. You're not writing an essay. You're not explaining your financial hardship. You're not apologizing or justifying. You're simply stating your position on each allegation in the complaint and preserving your legal rights. A basic answer includes your identifying information, your name, the case number, the court name. This matches what's on the summons and complaint. Responses to each allegation. The complaint is usually numbered, paragraph 1, paragraph 2, etc., and makes specific claims. You respond to each numbered paragraph with one of three answers. Admit if the allegation is completely true and you're not disputing it. For example, if they say, defendant lives at your address, and that's correct, you can admit that. Deny if the allegation is false or you're disputing it. For example, if they claim you owe a specific amount and you don't believe that's accurate, you deny it. Defendant lacks sufficient knowledge or information to form a belief as to the truth of this allegation and therefore denies same, if you genuinely don't know or don't have the information to confirm. This is often appropriate for allegations about the plaintiff's ownership of the debt or the calculation of the balance. Affirmative defenses. These are your legal defenses, things like, the statute of limitations has expired. Plaintiff lacks standing to sue. The amount claimed is incorrect and cannot be verified. Plaintiff has failed to provide documentation proving ownership of the debt. List any defenses that apply to your situation. You don't have to prove them in your answer. You just have to raise them so they're on the record. Demand for proof. Include a statement that you demand strict proof of all allegations. Make it clear they have to prove their case. You're not just handing them a judgment. Where do you get the forms? Many courts have answer forms on their websites. Some states have fill-in-the-blank templates specifically for debt collection cases. Legal aid organizations like lawhelp.org and NACA.net, National Association of Consumer Advocates, have sample forms and instructions. Use those resources. Don't overthink this. A simple, clear answer is better than no answer. Perfection is not required. Participation is required. Once you've prepared your answer, make copies. You need at least 3. One for the court, one for the plaintiff's attorney, one for your records. File it with the court. This usually means taking it to the courthouse in person, though some courts allow electronic filing. There may be a small filing fee, though you can often get that waived if you can't afford it by filing a fee waiver form. Do this before your deadline, not on the deadline day. Before. Give yourself buffer time in case something goes wrong or the court has questions. Serve a copy on the plaintiff's attorney. The complaint will list the attorney representing the plaintiff. You have to send them a copy of your answer, usually by mail. Include a certificate of service with your answer stating when and how you sent the copy to the plaintiff's attorney. Congratulations. You just filed your answer. You just prevented a default judgment. That one action, that one document, changes everything. Because now they have to actually prove their case. Now you're a defendant who's participating, who's demanding proof, who's not rolling over. Now you have leverage. Comment if you've ever been sued and didn't know you could file your own answer, if you thought you had to hire a lawyer you couldn't afford. Because that's what keeps people from responding, thinking it's too complicated, too expensive, too overwhelming, but it's not. It's a form, it's a deadline, it's participation, and it's your right. Okay, you filed your answer. Now what? Now you start building your defense by demanding the documentation they should have but often don't. This is called discovery. It's the phase of the lawsuit where both sides exchange information and evidence, where you can request documents from the plaintiff, where you can ask them to prove what they're claiming. And here's what you ask for, in writing formally through the court process. Proof of ownership, the chain of title showing how the debt went from the original creditor to the plaintiff. Every sale, every transfer, every assignment. If they're a debt buyer, they need documentation for every step of that chain. They need to prove they actually own the debt and have legal standing to sue on it. Full account history. Every transaction on the account from when it was opened until now. Every charge, every payment, every fee, every interest calculation. A complete, itemized history that shows how they arrived at the number they're suing for. The original signed contract or agreement. The document you allegedly signed agreeing to the terms. The credit card application. The loan agreement. The medical services consent form. Whatever document they claim created the debt obligation, calculation of the balance, a breakdown of principal, interest, fees, and costs, an explanation of how they calculated what they're claiming you owe, proof that every charge is legitimate and allowed under the original agreement and under state law. Any communication history, letters, calls, notices they sent, their internal notes on the account, anything showing how they tried to collect before filing the lawsuit. Most debt buyers don't have all of this. They bought a spreadsheet, maybe some basic account data, but not complete files. They're banking on you not asking. Banking on winning by default before discovery matters. But you're asking. You're making them produce documentation. And when they can't, or when what they produce is incomplete or inconsistent, you have grounds to argue that they haven't met their burden of proof. How do you request this? Through formal written requests called requests for production of documents, or interrogatories, written questions they have to answer under oath. Your court may have forms for this. Legal aid organizations have samples. Some states have specific rules about discovery in debt collection cases. Follow your court's procedures. Use proper forms. Send copies to the plaintiff's attorney and file proof with the court that you sent them. They have to respond, usually within 30 days, though it varies by jurisdiction. If they don't respond, you can file a motion to compel, asking the court to order them to provide the documents. If they still don't comply, you can ask the court to dismiss the case or impose sanctions. And here's the beautiful part. Often they'll settle or dismiss rather than go through discovery, because they know they don't have the documentation. They know their case is weak. They were counting on you not knowing to ask, but you asked. And that changes the entire dynamic of the case. Additionally, if during this process you discover they violated the Fair Debt Collection Practices Act, if they sued on time-barred debt, if they made false statements in the complaint, if they included fees they're not legally allowed to charge, you may have grounds for a counterclaim. You may be able to sue them for violating your rights under federal law. That flips the entire case. Suddenly, they're not just trying to collect from you, they're defending against your claim that they broke the law. That's leverage. That's settlement pressure working in your favor instead of against you. Let's talk about one of the most powerful defenses in debt collection lawsuits, the statute of limitations. Every state has a time limit for filing lawsuits on debts. It's called the statute of limitations. Once that time period expires, the debt becomes time-barred, meaning it's too old to sue on. The statute of limitations varies by state and by type of debt. For credit card debt and most written contracts, it's typically between 3 and 6 years. For oral contracts, sometimes shorter. For contracts under seal, sometimes longer. It depends on your state's law and how your state classifies the type of debt. Here's how it works. The clock starts running from the date of your last payment or the date of default, whichever is later. If you stop paying your credit card in January 2018 and your state's statute of limitations for written contracts is 4 years, the deadline would be January 2022. After that date, they can't legally sue you to collect. But here's what debt collectors do. They sue anyway. They file lawsuits on time-barred debt, hoping you don't know it's too old, hoping you don't raise the statute of limitations as a defense. Because if you don't raise it, the court won't automatically dismiss the case. It's an affirmative defense. You have to assert it. So if you're sued on a debt and you think it might be time-barred, check. When was your last payment? Look at your records, bank statements, any documentation you have. When did you last make a payment on this account? What's the statute of limitations in your state? Google your state statute of limitations credit card debt or check legal aid websites. Find out what the time limit is for your type of debt. Has the time expired? If it's been longer than the statute of limitations since your last payment, the debt is time-barred. If the debt is time-barred, raise this in your answer as an affirmative defense. The statute of limitations has expired and this action is barred by your state statute citation. If you can prove the debt is time-barred, The court must dismiss the case. It doesn't matter if you actually owe the money. It doesn't matter if the debt is legitimate. The law says it's too old to sue on, so the case gets dismissed. This is huge. This is a complete defense that ends the lawsuit. But, and this is critical, never restart the clock by accident. Making a payment on a time-barred debt can restart the statute of limitations in some states. Acknowledging the debt in writing in certain ways can restart it. Even making an oral promise to pay can restart it in some jurisdictions. So before you admit anything, before you pay anything, before you make any agreements, verify the age of the debt and whether the statute of limitations has expired. If it has, don't restart it. Use it as your defense and get the case dismissed. And one more thing. It's illegal under the FDCPA for debt collectors to sue or threaten to sue on time-barred debt if they know it's time-barred. If they do it anyway, you potentially have a claim against them for violating federal law. The statute of limitations is one of your strongest tools. Know it. Use it. Don't let them bully you into paying or settling a debt that's legally too old to collect. So you've filed your answer. You've requested discovery. You've raised your defenses. Now what? Now you either settle or you go to court. Settlement. Most debt collection cases that don't end in default judgment end in settlement. The parties agree to resolve the case for less than what was originally claimed, often with a payment plan, and the lawsuit is dismissed. Why do collectors settle? Because taking a case to trial costs them time and money. Because if you've raised valid defenses, especially if they can't produce proper documentation or the statute of limitations is questionable, they risk losing entirely. Because getting 40 or 50 or 60% of what they claimed is still profitable when they bought the debt for pennies. If the debt is legitimate, if you don't have strong defenses, if settling makes sense for your situation, you can negotiate. Here's how to do it right. Only negotiate after you've filed your answer and requested documentation. Never settle before responding to the lawsuit. Once you've preserved your legal rights and put pressure on them to prove their case, you negotiate from a position of strength, not panic. Make any settlement offer in writing. Never agree to terms over the phone. Get everything in writing before you pay $1. The written settlement agreement should clearly state the amount you're agreeing to pay, whether it's a lump sum or a payment plan, exactly how much and when. That this amount resolves the debt in full. Even if you're paying less than claimed, the agreement should say this payment satisfies the entire debt and no balance remains. How the debt will be reported to credit bureaus. Ideally, paid in full or settled in full, not settled for less than owed or other negative language if you can avoid it. That the plaintiff will dismiss the lawsuit with prejudice once payment is complete. With prejudice means they can't refile on the same debt later. That they won't sell or transfer any remaining balance. That this is final. That you're done. Only after you have that agreement in writing, signed by both parties, do you make payment. And when you do, never give them direct access to your bank account. Don't authorize automatic withdrawals. Don't provide your routing and account numbers. Pay by money order, cashier's check, or single transaction debit card payment. Something that's one-time and controlled by you. Keep copies of everything. The settlement agreement, proof of payment, the dismissal order once it's filed, proof that the debt was reported correctly to credit bureaus, complete documentation. If they violate the settlement agreement, if they keep trying to collect after you've paid what was agreed, if they report it incorrectly, if they sell the balance, you can take them back to court for breach of contract and potentially for FDCPA violations. Settlement can be a good option if done right, if done after you've established leverage, if done in writing with clear terms, if done with full documentation. But settling isn't required. If you have strong defenses, if you believe you don't owe the debt, if they can't prove their case, you can take it to trial. Which brings us to the next critical step. You get a notice. Your court date is set. This is it. This is when the case will be heard. What do? First, and most importantly, show up. Even if you've filed your answer, even if you've requested discovery, even if you think the case should have been dismissed already. Show up. Collectors count on no-shows. If you don't appear, and they do, they get a default judgment. All your work, filing your answer, raising defenses, becomes meaningless if you don't show up on the court date. So mark your calendar. Take time off work if necessary. Arrange transportation. Do whatever it takes to be there. Showing up is non-negotiable. What happens in court? Debt collection cases are usually heard quickly. The judge will call your case. Both sides will have an opportunity to present their position. It's not a dramatic trial like on TV. It's brief, procedural, focused on whether the plaintiff can prove their case. Here's what you do. Be respectful and calm. Address the judge as Your Honor. Don't interrupt. Don't argue with the plaintiff's attorney. Stay composed even if you're nervous. State your position clearly. Your Honor, I filed an answer denying the allegations and demanding proof. The plaintiff has not provided sufficient documentation showing they own this debt or that the amount claimed is accurate. I request that the case be dismissed for failure to prove standing and failure to meet the burden of proof. Or if you're raising statute of limitations, Your Honor, this debt is time-barred under state statute. My last payment was on date, which was over X years ago. The statute of limitations has expired and the case should be dismissed. Bring any documentation you have. If you have records showing payments they didn't credit, letters proving the debt is older than they claim, documentation contradicting their allegations, bring it. Organized. Clearly labeled, ready to present if the judge asks. Be prepared for the collector to not show up. Sometimes they file hundreds of cases and don't bother appearing for every hearing, especially if they know the defendant responded and will fight. If they don't show and you do, ask the judge to dismiss the case. Many judges will. The plaintiff had their chance and didn't appear. Case dismissed. Or be prepared for them to admit they can't prove their case. Sometimes in court, when actually pressed for documentation, the collector's attorney will acknowledge they don't have sufficient evidence. They'll ask for a continuance. You can object. Your Honor, they've had months to gather documentation. If they can't prove their case now, the case should be dismissed. Judges see debt collection cases all day. They know most debt buyers have weak documentation. If you show up, if you're organized, if you clearly state you're demanding proof, many judges will hold the plaintiff to their burden of proof. And if the plaintiff can't meet it, you win. Winning means the case is dismissed. The lawsuit is over. They can't garnish your wages. They can't levy your bank account. They lost. You defended yourself successfully. Even if you don't win outright, showing up and fighting often leads to better settlement offers. The collector sees you're serious. They see you know your rights. They see going to trial is risky for them. So they offer to settle for much less, sometimes 30 or 40% of the original amount, just to close the case. But none of that happens if you don't show up. Showing up is everything. It's the difference between default judgment and having a fighting chance. It's the difference between them winning automatically and you possibly winning or settling on favorable terms. Drop a comment if you've ever been to court for a debt case, or if the idea of going to court terrifies you. Because I know it's scary. It's intimidating. The system seems designed to make you feel powerless. But you're not powerless. You have rights. You have defenses. And showing up to assert them is how you use them. Okay, let's talk about the worst-case scenario. They win. The court issues a judgment in their favor. Now what? First, understand that a judgment is not the end of the world. It's not great, but it's not catastrophic. It's a legal determination that you owe the debt. It gives the collector certain powers to collect, but it doesn't mean they automatically take everything you have. What can they do with a judgment? Wage garnishment. In many states, they can garnish a percentage of your wages, typically up to 25% of your disposable income, though some states have lower limits and some states don't allow wage garnishment for most debts at all. Check your state's laws. Bank account levy. They can attempt to freeze and seize funds from your bank account. However, many types of income are exempt. Social Security, disability, veterans benefits, certain pensions. If your account contains only exempt funds, you can challenge the levy. Property liens. In some cases, they can place a lien on real property you own, like a house. The lien doesn't force immediate sale, but it means they'd get paid if you sell or refinance. What can you do after a judgment? Negotiate post-judgment settlement. Even after they win, they often settle for less. Collecting on a judgment takes effort. They have to locate your assets, file additional paperwork, potentially go through collection processes that cost time and money. Many will accept 40 to 60% paid in a lump sum or structured payments just to close the case. Claim exemptions. Certain income and property are protected by law from collection. If they try to garnish wages from exempt income, if they try to levy a bank account containing only Social Security, you can file an exemption claim to protect those funds. Every state has exemption laws. Legal aid organizations can help you understand what's protected. Set up a payment plan. Sometimes you can arrange payments directly with the collector or through the court. Voluntary payment plans can prevent garnishment and give you control over how much you pay and when. Appeal if there are grounds. If you believe the judgment was entered incorrectly, if you weren't properly served, if the court made a legal error, if there are grounds for appeal, you may be able to challenge it. This requires filing an appeal within a specific time frame, usually 30 days or less. It's complicated and usually requires an attorney, but it's an option if there's a legitimate basis. Consider bankruptcy if necessary. If you have multiple judgments, overwhelming debt, and no realistic way to pay, bankruptcy might be appropriate. Chapter 7. Bankruptcy can discharge most unsecured debt, including judgments. Chapter 13 creates a court-supervised payment plan. Bankruptcy is serious and has long-term consequences, but it's a legal tool designed to give people a fresh start when debt becomes truly unmanageable. Judgments also don't last forever. In many states, judgments expire after a certain number of years, often 5 to 10, unless the creditor renews them. If they don't renew, the judgment becomes unenforceable. And here's something important. Even after a judgment, you still have rights. Collectors still have to follow the law. They can't harass you. They can't threaten things they can't legally do. They can't violate exemptions. If they break the rules, you can still sue them for FDCPA violations even after they've won their case. A judgment is serious, but it's not the end. You still have options. You can still negotiate. You can still protect exempt income and property. You can still survive this and eventually move forward. Let's zoom out and look at the bigger picture of why debt lawsuits happen and what it means for you strategically. Debt lawsuits are built on fear and silence. The entire system relies on people not knowing their rights, not understanding the process, not responding, not fighting back. Collectors file lawsuits in bulk, hundreds or thousands at a time. They know most will end in default judgment because most defendants do nothing. Those default judgments give them power to collect through garnishment and levies. Even collecting on a fraction of those judgments makes the operation profitable because they bought the debts for pennies. They're playing a numbers game. They're not carefully evaluating each case. They're not making sure they have ironclad documentation for every account. They're filing based on spreadsheets and hoping defendants don't challenge anything. That's why your response matters so much. When you file an answer, when you demand documentation, when you raise defenses, when you show up to court, you stop being part of the easy bulk process. You become an actual case they have to work on, a case with risk, a case that might not be worth the effort. And often, when you stop being easy, they fold, they dismiss, they settle for much less. They move on to the easier targets who aren't fighting back. That's the system. It's designed to intimidate you into submission, to make you feel powerless, to make the process seem so complicated and scary that you give up before you start. But once you understand how it works, once you see that most of their power comes from your inaction, not from their strong legal position, everything changes. You realize they don't expect you to respond. They don't expect you to demand proof. They don't expect you to show up. They don't expect you to fight, but you do. And that changes the entire dynamic of the case, because suddenly you're not a statistic. You're a defendant who knows their rights, who's participating, who's making them work for it. And often, that's enough to shift the outcome in your favor. This doesn't mean you'll always win. Sometimes the debt is legitimate, the documentation is solid, the plaintiff has standing, and you genuinely owe what they claim. In those cases, settlement or payment arrangements might be your best option. But even then, even when you do owe the debt, responding and participating gives you leverage. It gives you options. It allows you to negotiate from a position of, I'm engaged and informed, rather than, I'm panicking and helpless. The system wants you helpless. It profits from your helplessness. Your response, your decision to participate, to understand, to fight back within the legal framework, disrupts that system. And here's what that means practically. Even if you're scared, even if you don't fully understand every legal nuance, even if you can't afford a lawyer, even if you feel overwhelmed and out of your depth, you can still file an answer. You can still deny the allegations and demand proof. You can still show up to court. You can still change the outcome from automatic loss to potential win or favorable settlement. You don't have to be perfect. You don't have to be a legal expert. You just have to participate. And participation, even imperfect participation, is infinitely better than silence. Let's talk about something that often gets overlooked. What you should not do when you're sued for debt. Because sometimes the mistakes people make are just as important as the strategies that work. Don't ignore it. We've said this repeatedly, but it bears repeating because it's the most common and most devastating mistake. You cannot ignore a lawsuit and hope it goes away. You cannot pretend it's not happening. You cannot assume it will resolve itself. Ignoring a lawsuit guarantees you lose. Default judgment. Automatic loss. Game over. No matter how scared you are, no matter how overwhelming it feels, respond. Even a basic, imperfect response is infinitely better than no response. Don't admit to the debt over the phone before consulting anyone. When collectors call, and they will call even after filing the lawsuit, they'll try to get you to acknowledge the debt, to say, yes, I owe this, to make partial payment promises. Don't do it. Don't admit anything. Don't acknowledge amounts. Don't make promises. Tell them, I'm not discussing this over the phone. All communication needs to be in writing. Contact my attorney, even if you don't have one yet. Anything you say can be used against you in court. Silence or no comment is safer than admissions. Don't make payments without a written settlement agreement. If you pay something, anything, without a clear written agreement about what that payment represents and what happens after, you've given them money with no guarantee of resolution. They can take your payment and keep suing. They can claim it was partial payment and you still owe the rest. Get everything in writing before paying $1. Everything. Don't give them access to your bank account. Never authorize automatic withdrawals. Never provide your routing and account numbers. Never sign anything giving them permission to debit your account. Once they have access, they can take more than agreed. They can drain your account. They can take money when you can't afford it. Control the payment method. Pay by check or money order or single-use payment method that you control. Don't restart the statute of limitations accidentally. If you're sued on old debt, don't make a payment. Don't acknowledge the debt in writing. Don't make promises to pay. Any of these actions can restart the clock on the statute of limitations in many states. If the debt is time-barred, that's your complete defense. Don't give it up by accident. Don't lie or make up defenses that aren't true. If you legitimately don't owe the debt, if it's not yours, if the amount is wrong, absolutely say so. But don't fabricate defenses. Don't claim you paid something you didn't pay. Don't claim identity theft if it wasn't identity theft. Courts take false statements seriously. Stick to the truth and to legitimate legal defenses. They can't prove standing. They can't verify the amount. The statute of limitations has expired. They violated the FDCPA. Those are real defenses that work. Made-up stories backfire. Don't skip your court date thinking they'll forget or it doesn't matter. Your court date is mandatory. Miss it and you lose everything you've worked for. They get their default judgment despite your answer, despite your defenses, despite everything. Show up. Even if you think the case might settle. Even if you think they won't appear. Show up. It's not optional. Don't assume you need a lawyer and then do nothing because you can't afford one. Lawyers are helpful. If you can get free legal aid or afford to hire someone, do it. But if you can't, that doesn't mean you're powerless. You can represent yourself. Courts have forms. Legal aid organizations have guides. You can file your own answer. You can request discovery. You can show up to court and present your defenses. It's not ideal to go it alone, but it's infinitely better than doing nothing because you think you need representation you can't get. Don't let shame prevent you from seeking help. Debt lawsuits are common. Millions of people deal with them. Legal aid organizations exist specifically to help people in your situation. Free consultations, court self-help centers, online resources, all available without judgment. The only bad question is the one you don't ask because you're too embarrassed. Ask. Seek help. Use available resources. These mistakes, ignoring, admitting, paying without agreements, giving bank access, restarting limitations, lying, missing court, assuming you need what you can't afford, staying silent from shame. These are what collectors count on. These are how they win cases they shouldn't win. Avoid these mistakes and you've already improved your position dramatically. Add in the affirmative strategies, responding, demanding proof, raising defenses, showing up, and you've given yourself a real fighting chance. Now let's address something important: the emotional and psychological side of being sued. Because this isn't just a legal process. It's a deeply stressful, often traumatic experience that affects your mental health and your daily life. Being sued feels like being attacked. It triggers fear, shame, anxiety, sometimes panic. You might have trouble sleeping. You might obsess about it constantly. You might feel like everyone knows, like you're being judged, like you've failed fundamentally. That's normal. That's human. That's not weakness. Being sued is legitimately stressful. The system is designed to be intimidating. The language is formal and threatening. The consequences feel catastrophic. Your nervous system responds to this as a threat because it is a threat. But here's what you need to remember. This is a legal process, not a moral judgment. You're not a bad person because you're being sued. You're not a failure because you owe money you can't pay right now. You're a person navigating a difficult situation in an economic system that pushes people into debt. Separate the legal reality from the emotional reality. Legally, this is a civil dispute about money. A business transaction gone wrong. A collector trying to use the court system to collect a debt. It's procedural. It's solvable. It has steps and strategies and outcomes that you can influence. Emotionally, it feels much bigger. It feels like your whole life is collapsing, like you're being judged by society, like you'll never recover from this. But those feelings, while valid and real, are not accurate predictions of the future. They're fear responses, stress responses, your brain trying to protect you from perceived catastrophe. Here's how to manage the emotional side while handling the legal side. Set boundaries with yourself about when you think about the lawsuit. Designate specific times, maybe an hour on Saturday morning, to work on your legal response, to research, to prepare documents. The rest of the week, as much as possible, you don't think about it. You've scheduled time to address it. That's enough. This prevents the constant rumination that makes anxiety unbearable. Talk to someone, a friend, a family member, a therapist, a support group. Break the silence, break the isolation. The shame you feel grows in secrecy. When you talk about it, when you realize other people have been through this, when you hear that someone else survived it, the shame loses some of its power. Focus on what you can control. You can't control whether you got sued. You can't control the past. You can't control the judge or the outcome entirely, but you can control whether you respond, whether you file your answer, whether you show up to court, whether you demand documentation. Focus on those actions. Taking action reduces helplessness. Celebrate small victories. You filed your answer on time? That's huge. That's worth acknowledging. You requested discovery? You're doing it. You showed up to court? You're fighting. These aren't nothing. These are wins, even if the case isn't over yet. Remember, this is temporary. It feels permanent when you're in it. But lawsuits end. They get dismissed or settled or resolved. Even worst case, even a judgment. Life goes on. People survive judgments. They recover financially. They rebuild. This is a chapter, not your whole story. Don't let the lawsuit consume your entire identity. You're not the person being sued. You're a person who happens to be dealing with a lawsuit among many other things in your life. You're still whoever you were before. You still have relationships, interests, capabilities, value. The lawsuit doesn't change your fundamental worth. If the stress becomes overwhelming, if you can't sleep for days, if you can't function at work, if you're having panic attacks, if you're thinking about harming yourself, that's a mental health emergency. Reach out to a mental health professional. Call a crisis line. Get support. The lawsuit is serious, but your health and safety are more serious. Protect yourself first. This is survivable, not easy, not painless, but survivable. And surviving means taking care of both the legal process and your mental health. Both matter. Both need attention. You can't effectively handle the legal side if your mental health is collapsing, and you can't find peace mentally if you're not addressing the legal side. So do both. Imperfectly. One step at a time. With support. With self-compassion. With the understanding that you're dealing with something genuinely difficult and you're doing your best. That's enough. Your best right now. In this situation, that's enough. Let's talk about what happens after the lawsuit is resolved one way or another. Because life continues. Your financial situation continues. And how you move forward matters. If you won. If the case was dismissed. If they couldn't prove their case. If the statute of limitations saved you. Congratulations. You defended yourself successfully. The lawsuit is over. They can't collect. They can't garnish. You're done with this particular case. But understand, the debt might not be gone entirely. Dismissal of a lawsuit doesn't always erase the debt. It means they couldn't collect through the court system in this case. But they might try other collection methods. They might sell the debt to another buyer who might try again. Check your state's rules about refiling and the statute of limitations. Make sure you understand your ongoing rights and protections. If you settled, if you negotiated a reduced amount or a payment plan, make sure you fulfill the settlement terms completely. Make every payment on time. Get proof of payment for everything. Once you've completed the terms, get written confirmation that the debt is satisfied and the case is dismissed with prejudice. Then monitor your credit reports to ensure it's reported correctly. If they violate the settlement agreement, you can take them back to court. If you lost, if there's a judgment against you, focus on protecting yourself from collection and eventually satisfying or settling the judgment. Know your state's exemption laws. Protect exempt income and assets. If they garnish wages, make sure they're not taking more than legally allowed. If they levy your bank account, challenge it if the funds are exempt. Consider negotiating a post-judgment settlement for less than the full amount. Consider bankruptcy if the debt is truly overwhelming and you have no way to pay. Regardless of outcome, learn from the experience. Understand what led to the debt and the lawsuit. Not to shame yourself, but to understand the patterns and circumstances. Was it medical debt you couldn't avoid? Job loss? Overspending? Lack of emergency savings? Understanding cause helps you plan to avoid similar situations in the future. Build an emergency fund if possible. Even a small one. $500 or $1,000 saved can prevent future debts from turning into lawsuits. It's a buffer between you and crisis. Know your rights now. You've been through this once. You've learned the system. You know how to respond to collection attempts. You know your rights under the FDCPA. You know about statutes of limitations and demanding documentation. That knowledge is permanent. You can use it to protect yourself in the future and to help others. Monitor your credit reports regularly. Check for inaccuracies. Dispute errors. Make sure paid or settled debts are reported correctly. Make sure dismissed cases aren't still showing as judgments. Your credit report is your financial record. Keep it accurate. Address any remaining debts proactively before they become lawsuits. If you have other old debts, other collection accounts, deal with them now. Send debt validation letters. Negotiate settlements. Check statutes of limitations. Don't wait until you're sued again. Handle it now while you can control the process. And importantly, don't carry shame about this. You were sued. You dealt with it. You survived it. That doesn't make you a failure. That makes you someone who faced a difficult situation and navigated it. Millions of people have been exactly where you are. You're not alone. You're not uniquely flawed. You're human, dealing with a system that's often set up to push people into these situations. Move forward. Rebuild if necessary. Use what you've learned. Protect yourself with knowledge and boundaries. And remember that this experience, as difficult as it was, is something you survived. That survival proves your resilience. Here's what I want you to take away from all of this. Debt lawsuits are built on fear, silence, and inaction. The entire system depends on people not knowing their rights, not understanding the process, not responding, not fighting back. When you respond, when you file your answer, when you demand documentation, when you raise defenses, when you show up to court, you disrupt that system. You stop being an automatic win. You become a case with risk. A defendant who knows their rights, someone who can't be steamrolled. And often, that's enough to change the outcome. To get the case dismissed, to negotiate a better settlement, to protect yourself from garnishment and levies, to survive with your finances and your dignity more intact than if you'd done nothing. You don't have to be perfect. You don't have to be a legal expert. You don't have to have all the answers. You just have to participate, to respond, to show up, to fight back within the legal system using the rights and tools available to you. Most people don't do that. Most people freeze. Most people do nothing. Most people hand the collector an automatic win because they're too scared or too confused or too overwhelmed to respond. But you're not going to be part of that majority. You're going to be the defendant who responds, who demands proof, who raises defenses, who shows up, who fights, not because it's easy, not because you're perfectly confident, but because you understand that silence equals surrender and action equals possibility. Because you know that doing something, even something imperfect, is infinitely better than doing nothing. They count on fear. They count on confusion. They count on you giving up before the fight even starts. But now you know. They don't have absolute power. They have to prove their case. They have to meet legal standards. They have to respect your rights. And when you make them do all that, when you participate instead of disappearing, you have leverage. You might not win every case. You might not get every lawsuit dismissed. But you give yourself a fighting chance. You change the dynamic from automatic loss to, we'll see how this plays out. And that change, that shift from helpless to engaged, makes all the difference. So if you get sued, when you get that envelope, when you see those papers, when the panic hits, remember, breathe. You're not powerless. You have rights. You have defenses. You have options. Read the lawsuit carefully. Understand what you're dealing with. Know your deadline. File your answer. Respond. Deny. Demand proof. Preserve your rights. Request documentation. Make them prove their case. Make them show they have standing and evidence. Check the statute of limitations. If the debt is time-barred, that's your complete defense. Show up to court. Don't miss your court date. Appear. Present your defenses. Settle if it makes sense, but only in writing. only with clear terms, only after you've established leverage. And through it all, take care of your mental health. This is stressful. It's legitimately hard. You're allowed to feel what you feel. But don't let the fear make your decisions. Don't let the shame keep you silent. Don't let the stress prevent you from taking the actions that protect you. You can survive this. You can fight back. You can navigate the system. Even when it feels overwhelming. Even when you're scared. Even when you don't know exactly what you're doing. Because participation, imperfect, uncertain, scared participation, is still participation. And it's still infinitely better than giving up. They don't expect you to fight. They expect you to disappear. They expect default judgment. They expect easy victory. Prove them wrong. Respond. Show up. Fight back. Because you're not helpless. You're not powerless. You're not automatically defeated just because you've been sued. You're a person with rights, with options, with the capacity to learn the system and use it to protect yourself. And that knowledge, that action, that refusal to surrender changes everything.